and other parts of. My role today is rather limited. I'm here to facilitate that the discussion takes place, and I'm grateful to Alexander for inviting me to moderate this session today. I am going to be introducing briefly the two speakers, and there's a third speaker that hopefully will join us later, subject to her court hearing being completed on good time and making back to her desk. But the whole idea, as you know, of this seminar is to look at the war in Ukraine and also to explore how law can be used to facilitate settlement of disputes in the current environment. A treaty has been in existence between Ukraine and Russia, VAT, for some time. This treaty, I understand, is about to be terminated for obvious reasons. But there is a lot of claims that individuals and corporations are being suffering, and arbitration does have a role to play in this context. I would like to first say a few things about why this matter is important. When we talk about arbitration, and often people speak about due process, and then some due process of being a purely procedural matter. However, the way the concept of due process has developed, and indeed the concept of due process paranoia, as some people will argue, and it's been used, is indicative of a broader concept of rule of law. The rule of law, a concept developed originally by Immanuel Kant in the 1700s, is there to ensure that states operate and comply with their own laws and with their own constitutions. Arbitration is also not operating in vacuum. Arbitration operates in a fashion that facilitates that the law is being observed and objective remedies exist by which one can protect the rights. And in that sense, arbitration, although a private system, is not a lawless or void of any sort of legal context and justification. And I see arbitration myself as a clear indication of an existence of a rule of law and as a promoter of that rule of law. Therefore, I am very much looking forward to hearing our speakers. And we will start with the one who is further to me at the moment, Uliana Bardin, who, if I'm not mistaken, is based in the US. And Uliana will be the first speaker, followed by Mrs. Carter. But Uliana has practiced for many years in arbitration, has an excellent reputation, and her CV is quite extensive. I'm not going to focus on that, but I think she has a lot to say, and a lot of that will be reflected of recent experiences or debates that she has had in the last 14, 2.5 years. Uliana, the floor is yours.
Sorry, Professor Liliana, but before your speech, I want to invite for a short welcome speech Vladimir Ustimenko, Director of Institute Legal Economical Research of National Academy of Science. Oh, sorry.
Thank you. Thank you. Dear colleagues, today we open the first series of scientific and practical events dedicated to the topic of international arbitration of the Ukrainian context. I am grateful to the colleague, Professor Lucas Mistelis, for his participation and for paying attention to the Ukrainian issue. Ukraine seeks justice, and it's the work lawyers to find legal ways to achieve it. Before the cooperation of scholars, attorneys, judges, and in development transparent, realistic, and effective mechanism for the protection property interest, the crucial for the recovery the Ukrainian economy. Using international experience and adapting to the modern Ukrainian relations is a priority for our institute. We support this event and wish the participant successful presentation. Thank you.
Thank you. And perhaps I should say something that Alexander already knows. As a very young academic, I spent a year in Donetsk, and I used to visit academician Valentin Mamutov regularly during my stay. I was based in Donetsk State University, but the institute was not very far. So I have very good memories of seeing him repeatedly, and I'm only delighted to be cooperating with your institute. Now, Ulyana, over to you.
Thank you very much to the organizers. Thank you very much to the National Academy. Thank you very much for Professor Mastelis. It is a great pleasure to be here today. So my task today is to briefly speak to you about the process of enforcement of arbitral awards. Essentially, when you go through an arbitration proceeding and then you receive that hard-fought award, what do you do with it? How do you actually monetize it? And how do you take advantage of what has been awarded to you? I did speak with Alexander in preparation for this call, and I understand that it might be beneficial for me to just very briefly speak about the process of arbitration before I actually turn to... Thank you. Thank you very much. Before I actually turn to the real topic that I have prepared for you. So as Professor Mastelis mentioned during his opening remarks, arbitration is a private dispute resolution mechanism, and it is really based on the parties' consent. So parties that did not consent to arbitration cannot arbitrate, and the arbitral tribunal is taking its authority and its power from the parties' arbitration agreement. Arbitration, there's several concepts that are very critical for arbitration, one of which is the seat of arbitration. And the seat is a fictitious place. It doesn't mean that anything physical needs to take place in that jurisdiction, but it means that the laws of that jurisdictions will typically be applicable to the procedural aspect of the arbitration. And the concept of the seat will become more relevant as we talk about the processes of enforcement and the related process of set-aside of arbitral awards. Another notion that is very important is the process of enforcement. And the process of enforcement is fairly well regulated around the globe because there are several key conventions that govern enforcement of arbitral awards. And these conventions have been pretty universally subscribed to by various states. So really, enforcing international arbitral awards is a process that is way more predictable than enforcing foreign court judgments currently. And we will discuss these two conventions in just a few moments. That said, there is certain complexity embedded in the process of enforcing of arbitral awards because there isn't one single forum to go and seek that enforcement. Essentially, the world is your playground, and it really requires a highly nuanced and thoughtful and strategic approach to determining where to go, into which jurisdiction to go to seek enforcement. And sometimes, in fact, people develop comprehensive strategies and use various stepping stones in order to achieve their final enforcement and collection of the award by seeking enforcement in several jurisdictions, and then sort of building up on that enforcement in one by seeking recognition in another one. But we will talk about that in a moment. What I will do right now, I'm going to try to share screen and present for you my presentation. Just bear with me 1 second, please. Okay. Can you see it?
Yes, brilliant. Thank you, Liana.
Thank you very much. Do you see it as a presentation or I think as a slideshow? Let's see.
Just file.
Well, then you need to press from the beginning.
From the beginning, yes. Okay, I can see it now. All right. Now you can
Great.
see it. Is this better now?
Yes.
Okay, wonderful. Thank you so much. So I will be covering in this presentation the fundamentals of the enforcement regime, really from the U.S. law perspective, because I am based in the United States, and that's where the jurisdiction from which I practice. In terms of enforcement of international arbitral awards, we will discuss the two key instruments that govern the enforcement. That's the New York Convention and the Exit Convention. And I will briefly summarize for you how they work and what assurances they provide for award creditors and what mechanisms they provide for our debtors to resist enforcement or, resist enforcement, and what the difference between them is. My apologies. I'm trying to. It doesn't happen very often that I share my own screen, so my sincere apologies for this.
Try the left bottom part of the screen.
Hold on. Do you still see my presentation?
Yes, still see. Maybe right, left, or up, down. Button.
Okay. Can you see slide 2 now by chance?
Yes, we see.
Okay.
But slide doesn't file, but okay.
Okay, great. So let's see if this continues working. All right, so I will, as I said, I will briefly speak to you about the New York Convention and the Exit Convention, just to draw the distinction between the two. So the Exit Convention applies to awards that are issued within the exit system. As some of you may know, EXIT stands for the International Center for Settlement of Investment Disputes, So it's an arbitral institution that has been created under the auspices of the World Bank, and specifically it is dedicated to resolve investment disputes. And I understand that in the second part of our presentation, we actually will focus on those, and specifically investment disputes between Russia and Ukraine, or I should say Ukraine, Russia. The Exit Convention applies only to the awards that were issued within the exit system. On the other hand, the New York Convention applies to all other arbitral awards, including investment treaty awards that were not issued within the exit system. So let's take a quick look at the requirements of each of these conventions. And I will try to go to the next slide.
Uliana, maybe I will share my screen.
That would be fantastic if you wouldn't mind, Alexander, because it clearly
I can help
is
you.
not working with
Just-
me. Thank you very much. So let me stop.
It's okay. It's sorry. One minute. Sorry. Desktop. Oh, do you see this?
Yeah, wonderful. Thank you very much. If you could please go to slide 4.
Mhm.
Thank you very much. So in this slide, I outlined for you the trajectory of an arbitration proceeding, whereby you really begin with a request for arbitration, go through party submissions, disclosure, hearings, then an award is issued, and then you get to the process of enforcement of arbitral awards. Now, under both the ICSID and the New York Convention, you can there is the so-called finality requirement. If you could please go to the next slide, Alexander. Thank you very much. So what does that mean? Let's talk about the 3 types of awards we typically have conceptually that exist. There is interim awards, partial awards, and final awards. Interim awards are those that resolve a request for interim or conservatory measures. Final awards is an award that resolves the entire dispute, all of the issues, and it's final and binding, and there's really nothing else to do. Partial awards is an award that finally resolves issues, but only some of the issues in the arbitration, meaning that after a partial award, there's going to be another award that's going to resolve the balance of the issues. So under the New York Convention, final and partial awards are enforceable. Interim awards, there is some discussion about their enforceability, but for the most part, interim awards and procedural orders are not enforceable under the New York Convention. The ICSID Convention is somewhat similar in that it also provides for the enforcement of the final award, but in the ICSID system, there's only one final award, meaning anything that is resolved, even if it is finally resolved, it still is resolved by virtue of either procedural order or a decision. And it can be decision on jurisdiction, decision on the merits, but it's not going to be called an award. So let's please skip slide 6 because it is just the cover slide, and then go to slide 7. Thank you very much. So this is a slide outlining, you know, some of the basics of the New York Convention, and shows to you how many jurisdictions around the globe have signed on to it. We can go to slide 8, please. Thank you. New York Convention essentially provides that the awards that are made in one signatory state must be enforced in another signatory state unless certain conditions preventing enforcement are present. The process that's outlined in the New York Convention is deceptively simple. I'm saying it is simple because it really sets out the promise on behalf of contracting states to take an arbitral award that has been issued in another contracting state and enforce it pursuant to pretty minimum standards. But it is also deceptively simple because the standard is so simple as outlined in the convention. There's quite often questions about the requirements and what is necessary and how courts are to interpret it, and that's really where a lot of issues come up. If you please skip slide 9 and go to slide 10. Thank you. So the process as outlined in the New York, the simplicity is that the New York Convention says in order to seek enforcement of arbitral award, the party needs to present only a duly authenticated copy of the original award, or rather original award or its duly authenticated copy, the arbitration agreement, and a certified translation of both of these documents into the language, in the formal language at the jurisdiction. I should also mention here that the New York Convention generally applies to both foreign awards and also to what's considered as non-domestic awards. Under US law, for example, non-domestic awards include those awards that were rendered inside of the US, meaning the seat, the place of arbitration was a city within the United States, but either one of the parties is a non-US party, or the property that's the award is about is located abroad, or performance is called for performance abroad, or there's one other foreign element that makes this award non-domestic. So convention would apply to both foreign arbitral awards, meaning arbitral awards that were issued in a different jurisdiction, and also non-domestic awards, meaning awards that do have this foreign element embedded in them. And Article 3, as you can see on the screen, is sort of the gist of the convention that essentially says that contracting states shall recognize and enforce awards that were issued in other member states. If we could please go to slide 11. Next slide. Thank you very much, Alexander. So two concepts that I would like to briefly distinguish for you is the concept of enforcement with the concept of set aside. Enforcement is provided for under the New York Convention, and that's the process that you have to go through in order to achieve that recognition of the award in the jurisdiction where you seek enforcement and converting it into the court judgment of that jurisdiction. Essentially, the set aside is the process whereby you would like to complain about the process in which the award was issued. Unlike enforcement that can take place in any jurisdiction that is party to the New York Convention, the set aside can only take place at the place of arbitration. That's why set aside that's why the seat of arbitration is such an important concept. Now, the New York Convention only covers the enforcement, not a set aside, but set aside does come up and is mentioned in the New York Convention. So how so? The New York Convention in Article 5, and you can see it on the screen, mentions the exceptions to enforcement, meaning the circumstances that would allow the award debtor to come back to the enforcing court and said, dear court, we believe in this particular case, you should not enforce the award because there are certain circumstances that were not allowed by the New York Convention to happen, and they did indeed happen in this place. For example, there was the incapacity of the contracting party. I mean, the contracting party that signed the arbitration agreement didn't have the proper capacity under the law. Or one of the parties, and that typically would be the losing party, the award debtor, that would complain that it did not have a fair opportunity to present its case. Or that the arbitral tribunal has acted in a manner where it exceeded its authority and has resolved issues that were not properly referred to it. So you see there's really 5 grounds. They're outlined for you in Article 5.1 on the screen. And these grounds typically can be taken into account by the court if the award debtor is coming to the court and requests that the court consider them and refuses to enforce arbitral awards on one of these grounds. There are 2 additional grounds that are of such significance that the court can actually, on its own initiative, decide to not enforce arbitral awards on that basis. So these 2 additional grounds, and they are outlined in Article 5.2 that you see on the screen, the box on the left, lower left. The 2 grounds are the subject matter that is the subject matter of the award, was not capable of being resolved by arbitration in the enforcing party. And then the recognition of the award would be contrary to the public policy of that state. So if the court believes that either of these requirements would be violated, it might, on its own initiative, decide to refuse enforcement. Now, I mentioned to you that the notion of set-aside is also mentioned in the New York Convention, even though the New York Convention does not provide for specific grounds for a set-aside. It does say that if there is a set-aside enforcement proceeding, the set-aside proceeding commenced at the seat of the arbitration, the enforcing court might decide to adjourn its decision on enforcement pending resolution of that set-aside proceeding. The court has discretion to make a decision. It does not need to defer to the decision of at the place of the court at the place of arbitration, but it does take into account the existence of that proceeding, and quite often the enforcing court might want to stay enforcement of arbitral award. If you could please go to next slide, please. I would like to very briefly speak about the statute of limitations. So the New York Convention itself does not provide for a specific time period where enforcement of the award is to be sought. So we therefore are looking at the law at the place of enforcement. Because I'm speaking on this topic from the US law perspective, I will mention to you that in the United States, a 3-year statute of limitation is available for purposes of enforcing of arbitral awards. Now, sometimes parties might, even though 3 years sounds like a long period of time, sometimes it does happen that those 3 years may pass without the enforcement petition having been filed. So there are some additional avenues that parties have considered and successfully actually been able to enforce arbitral awards by first going to a jurisdiction where the statute of limitation for enforcing an arbitral award is longer than 3 years, enforcing an award in that jurisdiction, and then seeking to enforce in the United States the judgment from that other jurisdiction. So they would essentially go around the 3-year statute of limitation requirements and take advantage of a longer statute of limitation that is available for enforcing of foreign court judgments. And typically, those statute of limitations are much longer, and they range between 10 and 20 years in the United States, depending on the state where enforcement is sought. Now, if we can go to the next slide, please, Alexandra. I want to very quickly talk to you about some of the procedural requirements for enforcing arbitral awards in the United States. So as we discussed a few moments ago, the New York Convention provides for a very simple process of enforcement. It doesn't tell you, apart from the 2 documents you need to present to the court, what else you need to do and what you need to achieve and what requirements you need to comply. But it does say that this enforcement will be done in accordance with the law at the place at the enforcement in the enforcement jurisdiction. So according to the United States law, in order to enforce an arbitral award, the petitioner would have to show that there is jurisdiction, and that is jurisdiction of the enforcing court has jurisdiction over the dispute, and then the court has jurisdiction over the debtor or its assets. It is also necessary to satisfy the so-called due process requirements or that has been developed by United States Supreme Court, and to show that really the award debtor has minimal contacts with the United States. But that's probably a topic like going in detail about what specifically that means. It probably is a presentation in and of itself. So I will just quickly mention to you that there are 2 types of well, let me actually take a step back. So jurisdiction over the dispute, meaning that the court is able to resolve this dispute. An award that has been issued under the New York Convention will provide for that. So that will automatically be satisfied if the petitioner can show that it is a New York Convention award. With respect to personal jurisdiction, that means jurisdiction over the award debtor, that needs to be shown by the petitioner. And there are two types of personal jurisdictions, two general types. One is called general jurisdiction, the other one is called specific jurisdiction. General jurisdiction over the award debtor means that the award debtor is considered to be at home. Again, that's sort of discussion of that concept is probably for another topic, but that really means that it regularly conducts business in the jurisdiction. And specific jurisdiction means that the claim itself has sufficient contact with that place. Meaning that, you know, the underlying dispute or the underlying conduct that led to the dispute took place in this jurisdiction, or that the defendant's contacts with the forum arose in the context of this arbitration. Now, there's one alternative to showing a personal jurisdiction that's called in rem jurisdiction, and that is jurisdiction over debtor's assets. So enforcement of an award with respect to in rem assets would be limited only to those assets, but that also is a possibility to proceed only against assets when general or specific jurisdiction is not available. If you could please go to slide 14. And Alexander, I would like to ask, I probably am, I want to make sure that I'm not exceeding my time. So how many minutes do I have?
I think maybe 5 minutes.
5 more minutes. Okay. So I will very briefly walk you through some of the key concepts that exist that would allow an award debtor to resist enforcement, so that we know how to avoid them and how to, if we are on the enforcing side, what to do to make sure that we don't fall into that trap. And then I probably will be happy to share my slides if you would like to share them, Alexander, because I don't believe that I'll be able to cover at any length either the exit convention or the enforcement of foreign court judgments. So let's very briefly talk about the concept of enforcement that's called forum nonconvenience. It's creature of U.S. common law. It essentially is not even very frequently used, but as its title suggests, sometimes our debtors have been successful in avoiding enforcement in the United States by merely arguing to the court that the United States is not a convenient forum for enforcing the arbitral awards, because neither the petitioner nor the debtor has any contacts with the forum, and therefore it really would be more proper to go to a different jurisdiction to seek enforcement. It is very rarely used. It was successfully used. Its use has been diminished over the recent years, but I wanted to mention this because it still is part of US law. Now, if you can go to the next slide. Another very common way of resisting enforcement is to commence a set-aside proceeding at the seat of the arbitration. When that happened, as I already mentioned, the court at the enforcement jurisdiction would very carefully consider whether it should proceed with enforcement or whether it should stay its enforcement process pending the resolution of the set-aside proceeding. In the US, there is the very sort of seminal case on this topic, which is the Europcar case that sets out the criteria for the court's decision as to whether to stay the decision or whether to proceed with it. And really what the court is trying to make a determination of is whether that set-aside proceeding is a bona fide proceeding because there was something that was untoward in the arbitration, or whether it is simply a maneuver, a tactic to avoid enforcement and delay, which goes contrary to the New York Convention requirements. I am just looking at, if we could please go to slide 18. So that's skipping 2 slides. Thank you. So I just want to very briefly mention the concept of sovereign immunity. And I know that we will have another presenter speak on this topic separately. But from the US perspective, the notion of sovereign immunity is set out in the US Foreign Sovereign Immunities Act. And the US Sovereign Immunities Act essentially provides that a foreign sovereign cannot be sued in the US court unless certain of the exceptions provided in that act are present. And one notion that I need to very briefly summarize for you, if we can go to the next slide, please, that there are 2 types of immunities, basically. That is immunity from suit and immunity from enforcement. And while it is generally accepted that an arbitration clause, and sometimes the convention, such as the New York Convention, actually provides or serves as a waiver of immunity from suit, meaning that the state that has signed an arbitration clause can be required to arbitrate. That does not necessarily follow that assets of that state will necessarily be subject to execution. So in order to proceed against those assets and attach them, for example, there generally needs to be a separate waiver. That doesn't happen very often, but it would be very helpful. There's also a lot of discussion in the US law as to what assets can be attachable. And typically assets that are used for commercial purposes can be attachable. Assets that are purely sovereign really are immune from execution. But there is, of course, a lot of discussion as to what happens in between, because some assets maybe you have the dual purpose assets and how to treat them. There's a lot of discussion in US law on that. But I will pause here. I will thank you very much and will be for your attention and will be available at the end to answer any questions you might have.
Well, thank you very much. And Professor, we have a connection now with Tatiana Nesterchuk. She is now in court and have few minutes for presentation.
Yes, of
Дуже
course.
дякую.
I just wanted to make one comment which follows very much from Uliana's excellent presentation. I think the New York Convention has a limited scope in the sense that it tries to facilitate enforcement and restrict the grounds on which enforcement can be resisted. But the 3 aspects that the New York Convention did not manage to harmonize is 1, the procedure that is used for execution of awards. That is referred back to domestic law. The concept of public policy, which in multiple places is also referred back to the issue of enforcing court. And last not least, a topic which is particularly relevant for the region is what issues might be capable of settlement by arbitration, which again are topics that are relevant to certain issues of enforcement. But overall, I think the harmonizing effect is and it's also in that spirit that the US courts have introduced also the additional defense of lack of personal jurisdiction when it comes to enforcing against states or state-owned entities, which is a rather peculiar, perhaps US matter and not applicable generally. So I think with that, these very brief comments, we can now turn to Tatiana Nesterchuk.
Thank you very much. Дуже дякую, Олександра, за запрошення. Так, I'm very sorry, just 1 second. I think I'm being called back to court. Maybe I can have a few minutes. Just to explain, I'm in the middle of a court hearing right now. I had a lunchtime break and it's going to come to an end in about 10 minutes. So I'm not going to have very much time to speak to you today. My topic was state immunity. And I had some slides, which Alexander has, but I'm not sure there's actually going to be time to go through the slides with you. So I will cover it very quickly in the next 7 or 8 minutes. Several sources, and I will explain the context. What I'd like to discuss is the context of the invocation of sovereign immunity when it comes to enforcement of foreign courts' judgments here in England. And the reason that I'm doing that is because I know that one of the hot topics in Ukraine right now is the enforcement of Ukrainian courts' judgments against the Russian Federation arising out of war losses. And what the Ukrainian advocates and courts really want to know is whether or not any of these judgments will be enforceable. So I will be talking about enforceability from a UK law perspective, and focusing on issues of sovereign immunity, because there are lots of other issues that would be relevant as well. So first of all, sources of the law on state immunity. Public international law, we're all aware of those. There are at least 2 conventions, the European Convention on State Immunity and the UN Convention on Jurisdictional Immunities. There's also the ICJ decisions, and most notable is Italy and Germany in 2012, and the new Italy and Germany case that is still ongoing. And then also state practice. I will not be covering those sources of law. I will be focusing on domestic law in England, Wales, which is the State Immunity Act 1978, which I think is very similar to the Foreign Sovereign Immunity Act that Iliana was talking about in the US. So again, as Iliana mentioned already, there are 2 different types of immunities. The first one is what I call jurisdictional immunity, and what Iliana said is immunity from suit. And that basically says that a state is immune from the jurisdiction of the courts of the United Kingdom, and effectively it applies to pretty much in any jurisdiction. A state, a court of one state cannot sit in judgment over another state. And the second immunity is immunity of state property from enforcement against it. So these 2 different immunities are the ones you'll have to surmount if you want to enforce your judgment. And by enforcing, I mean actually receive any costs, any damages. There are numerous exceptions to jurisdictional immunity. I will not go through them all, but effectively some of them are agreement by state. There's a special exception for arbitrations, and entering into a bilateral investment treaty, for instance, is subject to the exception because there's state agreeing for enforcement of arbitral awards. There's a commercial transaction exception, which is the one I'm using in a case I'm appearing in right now, which is a case that's been pursued against the State of Vatican. And the reason the claim is being allowed here in the UK is because it arises out of a commercial transaction. But the exception that I think is most applicable in cases of lawsuits against the Russian Federation in Ukraine is the tort exception. The tort exception is in Section 5 of the UK State Immunity Act, and that provides that a state is not immune as respects of proceedings where those proceedings are in respect of death and personal injury or damage or loss to tangible property caused by an act or omission within the UK. Now, why is this tort exception relevant? That is because of the way enforcement works. Enforcement of judgments against foreign states works in the UK. In my slides, which I hope Alexander will share with you later, I set out the relevant section of the Civil Jurisdiction in Judgments Act 1982, Section 31, which sets out the law applicable in the UK when it comes to the enforcement of judgments against foreign states. And that law essentially says that judgments against foreign states by a court of another state are enforceable if 2 conditions are satisfied. The first is that the foreign state court, so Ukrainian court, had jurisdiction under English law rules to proceed to hear the claim against another state. So Ukrainian court will have to show, or rather the claimant will have to show that Ukrainian court had jurisdiction. One, and two, the claimant will also have to show that Ukrainian court could dispense with sovereign immunity of the respondent state under the laws applicable in England, so under sections 2 to 11 of the State Immunity Act here in the UK. How does it work in practice? And I think this is the most important thing. The first one, the jurisdiction point, I will not go into the detail of that, but effectively a state court can assume jurisdiction here in the UK over any defendant who submits to jurisdiction, so agrees to appear, that doesn't apply to Russia, or who is present within the court's jurisdiction. Arguably, Russian Federation is present within the Ukrainian court's jurisdiction on the basis that Russian Federation has established its own local governments in Donetsk, Luhansk, and a few other regions, Zaporizhia and Kherson regions of Ukraine. So arguably presence is established. The second condition is showing that the Ukrainian courts disapplied Russian sovereign immunity according to the laws applicable in the UK. And this is the key takeaway I'd like you to take from this very brief presentation. The Ukrainian court's reasoning matters according to English courts. The English courts would be looking to see on what basis the Ukrainian courts decided that Russian Federation, in fact, was not immune from Ukrainian court's judgment. I believe that whilst there is no equivalent of Section 5, the tort exception of State Immunity Act in Ukraine, I believe that on application of customary international law, which is applicable in Ukraine, and also an application of the law and case law of the European Court of Human Rights, that the tort exception should be applied by the Ukrainian courts. So first of all, looking at the customary international law, having done a survey, and this is not in my slides, and perhaps I need to add this, having done a survey of different jurisdictions and the two international conventions, at least Australia, South Africa, US, UK, Israel, Hong Kong has the tort exception within their legislation. The tort exception also is included in two international conventions on the subject of state immunities. There's 1972 European Convention, the Basel Convention, and the 2004 UN Convention. Now, UN Convention is not yet enforced because it hasn't been ratified by a sufficient number of parties, but it is still a good evidence of customary international law, I believe. So there you have it. There is also a Strasbourg court decision in a case, the name of which escapes me, but it's a case against the UK, where Strasbourg court stated that whilst a sovereign state is usually immune from the jurisdiction of other states, that is not so in a case where the injury occurs on the territory of the forum state. So again, that is an application of the tort exception by Strasbourg court and a recognition of that. So I think the Ukrainian courts could follow that logic, the Strasbourg jurisprudence and the customary international law, and actually explain that the reason that they feel able to issue judgments against the Russian Federation is by the application of the tort exception. So that's all I have to say on the issue of jurisdictional immunity. When it comes to immunity of state property, that is more complicated. There's one sort of big exception to that under the State Immunity Act in the UK, and that is that enforcement could be made, an enforcement order could be made against any property of the state that has either been used or intended for use for commercial purposes, so the so-called commercial purpose exception. And then the question that most people ask is, well, you've got frozen Central Bank of Russia assets, could we just go and execute our judgment against those? The answer is very unlikely, and that is because under Section 14.4 of the State Immunity Act, there is a presumption here in the UK that the central bank property is not regarded as in use or intended to be used for commercial purposes. And that is a pretty strong presumption. It's been tested in one of the cases here in the UK, the AAG Capital Partners in the Republic of Kazakhstan, where the court, having granted third-party debt orders in respect of payments to the National Bank of Kazakhstan, so their central bank, on appeal, those orders were revoked. I think this is all I have time for today, and I do apologize that it is so quick. I really hope that if you have any questions, please pass them to Alexander, and I will make sure that I answer them in writing. Thank you very much indeed, colleagues.
Thank you very much, Tatiana, and we appreciate that you have been able to accommodate us within sort of a court hearing date. I think there might be some questions at the end, but I would rather turn now to Alexander Skarda of Kennedy's, who is going to address sort of one of the elephants in the room, whether one can use the current military sort of action in Ukraine and in the occupation parts of the Ukraine by Russia as a basis for in cases to be brought under investment treaties or in the energy sphere. So Alexander, over to you, and hopefully we'll have some time at the end for questions.
Okay, thank you very much, Professor Mistelis, for your introduction, and thank you to the National Academy of Science for the opportunity to speak today, and particularly to Alexander for his hard work in making today's event possible. I'm going to try and share my slide now. Could you just confirm whether you can see that?
That's fine.
That's visible, is it? Okay. So yes, today I'm going to be talking about the framework for investment treaty claims against Russia. I'm just going to try and... I've just changed the slide. Is that new slide visible?
Slide 2, I think.
Yeah. Okay. So the theme of today's my presentation is an overview, essentially, of the potential for investment treaty claims against Russia by Ukraine and by Ukrainian investors. As you may know, an investment treaty is simply an agreement between two states which gives nationals of each of the other state the opportunity to make investments into the second state, and it provides certain protections when investments are made. One of the great advantages of investment treaties is that they provide a direct right of action by way of arbitration by an investor against the state in which the investment has been made. And this is a big improvement on the old situation where investors had to rely on their home states to use diplomatic routes for the settling of disputes. And it's normal to talk of a home state, that is the state where the investor is from, and then the host state, which is the state into which the investment is made. Now, Russia has signed about 85 bilateral investment treaties, of which something like 64 of them are in force. The treaty between Ukraine and Russia is given there on the slide, dated 27th of November 1998, and I shall refer to that as the Ukraine-Russia BIT, or BIT. Russia also had signed the Energy Charter Treaty, and that provisionally applied with respect to Russia until 2009, when it terminated the application of that treaty. And of course, the Energy Charter Treaty is the treaty pursuant to which the shareholders of UKOS made their claim against Russia, which led to the largest arbitration award in history of about $50 billion, which now amounts to something like 60 billion when interest is taken into account. And that award is being enforced at the moment in different jurisdictions, including the United States, the United Kingdom, and also the Netherlands. I'm changing my slide. Alexander, do you mind sharing your screen? Because, there we go. Investment arbitration. So, like most investment treaties, the Ukraine-Russia BIT contains dispute resolution procedure. That's contained in Article 9 of the investment treaty. And as with most investment treaties, it offers the opportunity of arbitration, which in this case is either arbitration with the Chamber of Commerce in Stockholm or an ad hoc arbitration in accordance with the UNCITRAL rules. when arbitrations take place under investment treaties, the arbitral tribunal may have to consider a variety of different types of law and different types of rules. Of course, because investment treaties are treaties, then international law applies, which means that when questions arise, perhaps relating to the parties, the agreement of treaties, or the implementation or the interpretation of treaties, then of course the Vienna Convention 1969 applies, or the customary law equivalents to the Vienna Convention. And that includes Article 31, which is the general rule of interpretation, which provides, of course, that the treaties should be interpreted in good faith, using the natural meaning of words in their context, and with the object and purpose of the treaty in mind. Within investment treaty arbitration, there's also now a substantial body of international law and practice relating to investment treaty disputes. There's no such thing as precedent within international arbitration, but the decisions of previous arbitral tribunals may be guiding or helpful to tribunals when deciding disputes. Then there's the law of state responsibility, which applies with respect to questions of a state's responsibility when there's been a breach of international law. And that is contained within the ILC articles on state responsibility, which also reflects customary international law. And finally, in the context of a war, well, then it's possible that the rules of war will apply in a dispute, which this is known as international humanitarian law, and the principal conventions are the Hague Conventions, the Geneva Conventions, and the Geneva Protocol. It might be thought that in times of war, treaties would be terminated automatically, but that's not the case. Although potentially there's arguments available to a party under the Vienna Convention to say that a treaty has ceased to have any effect when there's a war between the parties to the treaty. By and large now, the presumption is that treaties continue in effect. This is reflected in Article 3 of the draft articles on the effects of armed conflicts and treaties. And Article 7 of the draft articles, and in the annex to the articles, there is a list of the type of treaties, the subject matter of which generally implies that the treaties continue in operation during an armed conflict. And that list includes treaties of friendship and commerce and navigation, and also agreements concerning private rights. And bilateral investment treaties are one type of agreement concerning private rights. So by and large, a BIT will survive even though there is a war going on between the two state parties to the treaty. As it happens, and as Professor Nestelis mentioned at the beginning, there has in fact been steps taken towards the termination of the Ukraine-Russia BIT by Ukraine. I think a law was passed in August last year, which according to the law and the terms of the treaty means that the termination will take effect in January 2025. However, there is what is known as a sunset clause at Article 14 of the BIT, and that provides at Article 14.3 that with respect to investments which were carried out before the termination of the agreement and are subject to it, the provisions of the other articles of the agreement shall remain valid within the next 10 years after the date of termination. So that means that with respect to investments that are made up until the date of termination, i.e. January 2025, then the protections under the treaty will last for another 10 years, that is up until January 2035. Now, as far as I understand, the reasons for Ukraine having started the termination of the treaty are basically the calculation that using the sunset clause provision, the protections will still be available to Ukrainian investors with respect to their investments for another 10 years. And the size of claims that stand to be made by Ukrainian investors against Russia are going to be possibly much larger than any counterclaims which would come from Russia under the treaty. As with any bilateral investment treaty, there are a number of qualifying steps that any claimant will have to make in order to assert a claim in international arbitration. One of these is that the claimant will have to show that he's an investor within the meaning of the BIT. Now, in the case of the Ukraine-Russia BIT, it's fairly standard wording of the sort that you can see in most BITs, simply that the investor is going to be either a legal or a natural person who is a citizen of one of the contracting parties and has the legal capability to make an investment into the other contracting party. And then the second defining factor is the idea of investments themselves, i.e. what is an investment for the purpose of the treaty? And as with the majority of treaties, that's a very broad definition of investments. And in the case of Article 1.1 under the Ukraine-Russia BIT, it includes movable and immovable property, funds, securities, intellectual property, and simple contractual rights. However, for them to be protected under the treaty, those must be investments which are made in the territory of the other contracting state. There's also two other requirements. One is of territory, which I've just referred to, and also the requirement of time, the temporal application of the treaty. Now, the word territory is defined at Article 1.4 of the Ukraine-Russia BIT as the territory of the Russian Federation or the territory of Ukraine, and also the respective exclusive economic zone and the continental shelf as defined in conformity with international law. And I'm going to come on to that in a bit more detail. The temporal requirement is that at Article 12 of the BIT, which says that the agreement shall apply to all investments carried out by the investors of one contracting party on the territory of the other since January 1992. Now, it's worth considering briefly the concept of territorial link, because under international law, there's a notion of extraterritoriality. That is the idea that a state can be responsible for acts of its agents which take place outside its own sovereign territory in areas which are under its effective control. And this concept is seen in the context of international humanitarian law, namely the law of belligerent occupation, which deals with the situation where the occupying forces of one state take over the territory of another state. It's also seen, this concept, in the context of human rights law, particularly Article 1 of the European Convention of Human Rights. And that Article 1 basically requires the state party to the European Convention to provide the protections of the Convention to anybody within its jurisdiction. And it really follows from the case of Loizadu in Turkey, where the European Court of Human Rights in that case decided that the concept of the responsibilities under Article 1 and the nature of territoriality extends beyond the sovereign borders of the state and also to the territory which is under its effective control. And that principle has now been applied a couple of times within the context of Russia's aggressive actions towards Ukraine. Firstly, the decision of the European Court in Ukraine versus Russia of December 2020, which decided that since 2014, Crimea had been under the effective control of Russia, and therefore Russia was obliged to extend the protections of the Human Rights Act to the people of Crimea. And secondly, the 2023 decision of Ukraine and Netherlands versus Russia in relation to Donbass, where the European Court decided that the so-called People's Republics of Luhansk and Donetsk were effectively under the control of Russia, and therefore all their actions could be attributed towards Russia. Now, this idea of effective control has now been applied a number of times in the context of investment treaty arbitration. And I'm referring, of course, to the Crimea cases, of which there is a list in this slide. The basic positions of Ukrainian parties on the one hand and Russian parties on the other is essentially as follows. Ukrainian claimants are asserting that even though Crimea remains sovereign territory of Ukraine, which is something with which the international community has agreed, for the purposes of the investment treaty between Russia and Ukraine, Russia has, since its illegal annexation in 2014, Russia has assumed the responsibilities to protect investors within the territory of Crimea, even though that territory is formally speaking Ukrainian. The Russian position, in summary, has generally been that the obligations of protection only apply to investments which have been made since 2014, and also that it doesn't apply anyway in the case of Crimea. Sorry, the BIT does not apply anyway, because this is sovereign territory of Russia, as they say. Now, of course, in all these cases, pretty much, the arguments of Russia have been rejected, and I'm just going to refer to two of them. The first is the Stabil case in the decision of June 2017, where basically the tribunal decided that, yes, it applied to Ukrainian investments within Crimea, and it gave the term territory a very broad meaning, and I'm going to quote, holding that the ordinary meaning of territory within the Ukrainian-Russia BIT includes areas over which the contracting parties exercise jurisdiction and de facto control, even if they hold no lawful title under international law. And then secondly, a decision of the Hague Court of Appeal, which was made in respect to Russia's application to set aside awards in the Belbek, Everest Estate, Naftogaz and Privatbank arbitrations. And what Russia tried to say in this case was that basically all these investments had been made prior to 2014, prior to Russia's illegal annexation. Therefore, the obligations under the BIT did not extend to Russia. However, that was rejected by the tribunals and also the Hague Court of Appeal, which decided that for an investment to fall within the scope of the bilateral investment treaty, it did not have to be situated in the territory of the respondent state, i.e. Russia from the outside. What mattered simply was that the investment was located in the territory of the respondent state at the time of the alleged breach of the BIT. Now, all these Crimea cases, they've all moved beyond the jurisdiction stage, they've gone to merits phases, and in many cases, they've reached final awards and are now being enforced internationally, including enforcement in the United States. And apparently, for example, the Naftogaz award, which comes to some $5 billion, has entered enforcement proceedings within the United States and in the United Kingdom. Now, these Crimea cases, they concern classic situations of expropriation. That is, the claimants in those cases were asserting that Russia and its proxied had taken expropriatory steps towards businesses by taking assets either through physical force or through regulation. However, since the full-scale invasion by Russia in 2022, there are now perhaps different sorts of claims which might be advanced under the bilateral investment treaty. Basically, claims for war damage. So really, cases for Ukrainian investors now are going to concern two types of damage. That is either expropriation or claims for damage and destruction inflicted by armed conflict. And given the findings in the Crimea cases and what Russia has done subsequently in eastern Ukraine and in southern Ukraine, including the supposed incorporation of parts of those territories into the subjects of the Russian Federation, Russia now stands to face liability for all its actions under the bilateral investment treaty in respect of Ukrainian assets which have been either taken, seized illegally, or have been destroyed through Russian action. So I'm going to move now quickly on to some of the standards of protection which exist under the bilateral investment treaty. But first, I'm going to make a quick comment about this, which is the most favored nation clause within the BIT, Article 3.1. It's a fairly standard provision to be found in most bilateral investment treaties. And what it does is, the effect of it is to grant investors under the Russia-Ukraine BIT protection which is no worse than protection which is offered by, or equal to, protection which is offered by Russia with respect to other third-party states under other bilateral treaties. So the effect of it is that if something perhaps is not evident or is missing from the Ukraine-Russia bilateral treaty, a Ukraine investor will be able to refer to another bilateral treaty that Russia has entered into with another state. And if the protections in that other treaty are better than the protections in the Ukraine-Russia bilateral treaty, well, then the Ukraine investor will be able to rely as well on those protections. And just as an example, this sort of procedure has already been applied with respect to the bilateral investment treaty between Russia and Ukraine in the Tatneft versus Ukraine case, which in fact concerned a Russian claimant against Ukraine. And in that case, it was held that yes, Article 3.1 was capable of importing different and better protections from other international instruments, namely the UK-Ukraine BIT and also the Energy Charter Treaty, and they could be imported into the Ukraine-Russia BIT. So the main measure of protection, which is going to apply in cases where, for example, Russian forces have been stealing assets of Ukraine, whether it's machinery, whether it's other form of property, perhaps Ukrainian grain stores. That's primarily going to be a situation of expropriation, which is covered by the Ukraine-Russia BIT. Quote is given there. And essentially, Article 5.1 sets out that no property of an investor shall be subject to expropriation, nationalization, or equivalent measures. And that any expropriation that takes place, it should be a lawful expropriation, namely, it should not be discriminatory, and it should entail prompt, adequate, and effective compensation. So that's the principal provision regarding the steps which might lead to the taking of Ukrainian property. And that has been relied on heavily, as I said previously, in the Crimea cases. However, as far as war damage is concerned, there's a series of possible clauses which may apply and which tend to be evident in in bilateral investment treaties. These are compensation for losses clauses, extended war clauses, and full protection and security clauses. Now on the screen, I've put the compensation for losses clause, which is to be found at Article 6 of the Ukraine-Russia BIT. And in reality, this isn't very different from a most favored nation treatment clause, because what it basically does is that it says to the investors, the host state will give security protection in relation to war damage, which is no worse than what it gives under other treaties to which it is a party. So this of itself does not create any standards, absolute standards against which a claim could be made. Now, there isn't actually an extended war clause within the Ukraine-Russia BIT. There is, however, an extended war clause within the Energy Charter Treaty at Article 12, to which both Russia was a party and to which Ukraine is a party. Now that extended war clause does a number of things. However, one of the things it does is that it gives rights of action or it requires protection to be given in relation to requisition of property and also destruction caused by war. Now, whether a Ukrainian claimant could rely on the Article 12 within the Energy Charter Treaty and essentially incorporate it into the bilateral investment treaty is open to question. And it's also open to question as to whether that would be desirable, because firstly, the Energy Charter Treaty only applies to investments in the energy sector. Secondly, Russia's termination of the application of the ECT took effect in 2009. So it would only apply to investments that had been made prior to 2009. And thirdly, the definition of territory in the ECT is in fact different to that contained in the bilateral investment treaty. And in fact, the word territory is not used, the word area is used instead. An area, as defined in the ECT, refers only to sovereign territory of the state parties. Now, it's unlikely that a Ukrainian claimant is going to be wanting to rely on a provision which essentially concedes the fact that occupied territory is Russian sovereign territory. So it's debatable whether this is of any real assistance. However, arguably, it may be possible to say that the definition of territory is not brought into the Ukraine-Russia BIT, that as it's a hurdle to the treaty applying, that the definition of territory is the one that's contained within the Russia-Ukraine BIT, and not the one that's contained in the ECT. But it just goes to show that in making claims under investment treaties, it's necessary to look beyond the framework of the investment treaty as well, and to see what other possible protections may be available. I'm moving on now to the full protection and security provision, which is Article 2.2 of the Ukraine-Russia BIT. And full protection and security clauses are very common in bilateral investment treaties. And the one in the Ukraine-Russia BIT is as given there. There's a potential question as to whether, given the wording of this particular clause, it is limited perhaps to legal protection, whereas in fact, full protection and security clauses are supposed also to apply to physical protection. Generally speaking, these clauses impose two duties on a host state. One is the duty to protect, i.e. the duty to protect the investor's property from violence, perhaps by third-party actors. And the second duty is the duty to refrain, which is the host state should stop its own powers from causing any damage to investor property. Now, both these obligations are not strict liability, they are due diligence obligations, and they require a reasonable use of the host state's capabilities. And of course, in this context, when we're talking about Eastern Ukraine, Southern Ukraine, and Crimea, we're essentially talking about Russia as the host state. Now, as I said, there's a question as to whether this particular provision applies to physical threat as opposed to just legal risk. In any event, it's possible that by using the most favored nation clause within the Ukraine-Russia BIT, it's possible to refer to clauses in other BITs, and the strongest, if you like, most comprehensive BIT that Russia has entered into is the 1998 BIT with Japan. And that has wording which quite clearly involves constant protection and security within the territory of the other contracting party. And that is a physical protection clause. Similarly, just another example, the Lithuania-Russia BIT of 1999 also gives a guarantee of full protection and security, which would be capable of covering physical protection. I've just made reference on this slide to two cases. Firstly, Gurus and Syria was a case in which basically all these principles have been shown to work. That is, the Turkish claimant in Gurus versus Syria had suffered damage to property due to the war in Syria. However, the Turkish-Syrian BIT was slightly deficient in terms of the war protection it offered. So instead, the claimant was able to refer to the Italy-Syria BIT to rely on a clause in that BIT which offered much better war protection. And then I've referred also to the AAPL case versus Sri Lanka case, which is really quite a good illustration of the complexities that arise when making claims in relation to conflict situations under BITs, because in this case there were two possible provisions which the claimant, a UK claimant, could have was relying on in relation to the UK Sri Lanka BIT. Now, with respect to the full protection and security clause in that BIT, the tribunal held that the claimant did not succeed. That was because the claimant had to prove firstly that the damage to its property had been caused by the government of Sri Lanka and not by rebel insurgents. Secondly, that the destruction to the property had occurred as a result of combat. And finally, that there was no military necessity for the action that was taken and led to the damage. So there were three hurdles that the claimant had to get over there, and it didn't succeed. However, it did manage to succeed under a different clause in the BIT, which concerned losses specifically caused by war and insurrection. And in that case, and in respect of that provision, the tribunal decided that the respondent, i.e. Sri Lanka, had failed in its obligation of due diligence with respect to the property of the claimant.
Alexander, sorry, I should remind you about time.
Okay, thank you. I'll be quick. So this slide, there's always the question of attribution within the context of investment treaty arbitration. When a wrong has been committed by a state, well, it's necessary to be able to show that the wrong that was committed was done by agents of the state, and these issues are covered by the articles on state responsibility, which are given there. I'm not going to go through those now, but one of course, nuance in the context perhaps of what has happened in Ukraine is to what extent private military companies such as Wagner Group, to what extent paramilitary organizations can be made held liable, and in turn Russia held liable for their actions. Finally, in theory, there are defenses available to a respondent state for breaches of international law. And I've put two here on the slide. One is the idea of force majeure, which is a familiar concept to us all, no doubt. The other is the idea of necessity, i.e. the idea that a state may be excused its internationally wrongful act if it can show that it was necessary, that there was no other way of doing what it had to do. Now, it's highly unlikely that Russia will be able to rely on these sorts of provisions, because in both cases, both in respect of force majeure and in respect of necessity, Russia, as the invading state, has contributed towards the situation that is now taking place in Ukraine, of course, it's an aggressor state acting in breach of international law. So it's very unlikely that it would be able to rely upon these potential defenses. And finally, what does an arbitration lead to? Well, an arbitration is supposed to lead to reparation under international law. Normally, there's a number of options for reparation, one of which is restitution, i.e. the parties are returned to the full position as if the breach of international law had never occurred. However, more often than not, a claimant party in international arbitration is seeking compensation. And within the framework of international arbitration, compensation can be for all types of loss, including loss of profits. But basically, damages within the context of an investment treaty arbitration should try as far as possible to put the claimant in the situation which would have existed had there not been an internationally wrongful act. I think I will conclude there just by saying that it is fair to say that international arbitration and investment treaty arbitration can be a long and expensive process with requirement of resources. It's also fair to say that currently, internationally, between Ukraine and its international partners, there's discussions, of course, regarding claims commissions and how to set up mechanisms for reparation by Russia towards Ukraine. However, international investment arbitration remains a powerful tool for holding Russia to account. It provides a fair and neutral form of dispute resolution, and as we've heard from Uliana earlier, will also lead to arbitration awards, which are capable of being enforced internationally. Thank you very much for your attention. I'll be very happy to address any questions.
Thank you, Alexander. It has been indeed a very rich presentation with so many aspects. I'm not sure whether we'll have time for questions because, as I understand, in the next 6 minutes there will be another panel starting, and we need to allow for that. But one comment I would like to make in relation to the Energy Charter Treaty is, of course, it has also the denial of benefits clause, which is a clause which has not really been tested in these circumstances. And I wonder whether this would be, how that will be tested going forward. But all I think that is critical at this stage is to say that we have had 3 incredibly insightful presentations by Uliana, Tatiana, and Alexander. And I'm pretty sure as the event is being recorded, Alexander Chernik will let us have any questions that may come, and we will also engage with the audience in all possible ways. Thank you.
Thank you, Professor. Thank you for your participation. And we just need 5 minutes for a short pause for prepare next our session with our next speakers. And all participators, if you have some question, you can send to me or maybe for official mail of Institute of Economical Legal Research of National Academy of Science, and we'll send your question to our speakers. Thank you for our brilliant speakers and Professor for moderation our meeting. I think our main goal to show to Ukraine, to British lawyers, possibility of international arbitration as one of the way for justice for Ukraine. And thank you very much. So let's meet after 5 minutes coffee break in our next session about enforcement decision. Thank you.
Thank you.
Good afternoon, everyone. Thank you, Alexander, for inviting to moderating this session. It's a great pleasure and honor for me. My name is Andrei Stutsenko. I'm a counsel at Astos law firm, and today I will try to lead the discussion of our highly distinguished guests at this panel. And I want to start actually by saying that also, although the name of the panel sounds like enforcement of arbitral decisions, it seems that some of the speakers will talk about Ukrainian litigation proceedings and enforcement of Ukrainian court judgments. And those issues are actually very practical in Ukraine and elsewhere, because including our firm, lawyers in Ukraine work on such cases for Ukrainian businesses which suffered as a result of Russian aggression, but for various reasons, either purely legal one or economic one, are not able to file investment arbitration claims, so they often resort to Ukrainian courts. And there are quite many Ukrainian court decisions have been issued already, but it would be interesting to hear from our guest, in particular, whether any attempts are known to enforce those decisions against Russia or Russian entities, either in Ukraine or abroad. Another not less important issue is the seizure of Russian frozen assets, and my colleague from Astas, Alexander Frolov, will talk about this subject. So without further ado, I think I will pass the word to our first speaker, Amenak Aganesian, who is an attorney in Ukraine. And he will speak about the practice of enforcement of foreign arbitration decisions in Ukraine.
Andrei, thank you very much. Thank you, Alexander, for inviting, and good afternoon, everyone. Thank you again for your invitation. I'm really glad to share my experience from a bit different perspective. Despite the announced topic of my speech was enforcement of arbitral awards, I would focus, since I'm not practicing law in a classical sense for 2 years, since the full-scale invasion, but I have the perspective of policymakers in the United States and the United Kingdom and in Ukraine regarding the issues which are concerning with regard to the enforcement of the awards of judgments and asset tracing. Therefore, I would love to speak about the full strategy of enforcement of judgments, which is like the key issue, which bothers the minds of professionals involved in civil military cooperation and involved in intelligence community. So, speaking of I'll start with 2 concerning points which actually hinder the full-scale execution of judgments and involvement of Ukrainian government in particular in the proceedings which relate to the compensation of damages. So first of all, BITs, or bilateral investment treaties, they were originally designed to facilitate the peaceful investments, and they are not naturally equipped to handle scenarios involving war or crimes against humanity. Applying these treaties to such contexts involves significant challenges, not to speak about domestic decisions of domestic courts. However, in lieu of absence of other plausible mechanisms of unified redress, like the announced International Claim Commission or the inability of other international judicial institutions like European Court of Human Rights or International Court of Justice just to resolve this issue. Investment state dispute resolution seems to be an effective avenue. The second issue, which arises constantly in the discussions, is the sovereign immunity, which protects state-owned property on foreign soil from seizure for state sovereign actions, including military aggression. This is a rule which was confirmed at the highest level of international justice. And this legal norm has endured for decades because states owning substantial property abroad want to protect these assets from foreign confiscation. As a result, this principle shields Russian assets as well. So these two issues, like I said, they gave rise to skeptical, let's say, sentiments regarding the favorable outcomes of litigation against Russia. However, to my mind, in case of a thoroughly elaborated strategy, international arbitration, and including even domestic judgments, these could be proper tools and have the potential of, I would say, waging economic warfare against the aggressor state. So speaking of the strategy, I would highlight several key points. So given the type of the first one is the type of the award or decision. So whether it is a domestic decision, whether it is an award, arbitral award under which is enforceable under whether New York Convention or ICSID Convention, that defines the full strategy and has encapsulated I would say, the perspectives of success of the enforcement. Of course, to cut a long story short, the most favorable avenue would be ICSID Convention because, as participants probably know, the awards of ICSID do not require the recognition by the host state. Therefore, the further pillar of the strategy is the asset tracing. I pointed out as a second pillar because it has to be done before even any proceedings are commenced. So Russian government, the corporations which are tied up with warmongering businesses or warmongers, they of course employ all the full spectrum of tools which were previously used by tax evaders or just to facilitate any kind of shenanigans. So therefore, the issue of location of assets and freezing them in the sense of making them immovable is of critical importance. Yes, please.
It's okay. It's a mistake. You continue, please.
Okay.
Yes.
Thank you very much. I'll try to be brief. Well, the assets recovery, like I said, is of critical importance, and here is the point where civil-military cooperation has to be brought to another level. There are a lot of welcoming news regarding cooperation of our asset recovery and management agency, ARMA, with European institutions like ARO, Asset Recovery Office, as well as private initiatives like Orbis Bureau and Van Dyke. And all of these initiatives are basically the tools which have to be employed by literally each and every legal counsels. These law firms which represents the victim or which represent the victims of like Russian aggression. Ukrainian government has to work towards establishing a proper communication of these counselors to this kind of institutions and initiatives. So they would be able to obtain information which is relevant to the representation of their clients. So after we define the, according to the first pillar, after we define the type of the award or the judgment we want to enforce, after we define the assets, we establish their location, and presumably they're immovable, we have to establish the favorable jurisdiction of enforcement. Speaking of domestic Ukrainian judgments, it's quite problematic, and colleagues who are representing the clients who have already these kind of judgments, they know that enforcement of Ukrainian judgments is quite challenging. However, in defining the favorable jurisdiction, we have to take into consideration several crucial points. The first one is the pace of recognition, the tempo of recognition and enforcement of the award, as well as the possibility to overcome the sovereign immunity and the efficiency of interim measures, including those related to the assets phase. A good example can serve Belgium, which holds a significant portion of Russian sovereign assets. Their legislation explicitly prohibits invoking sovereign immunity as a defense to the enforcement of arbitral awards against a state. Therefore, there is a good prospect of securing Russia's assets frozen in Belgium through arbitration under the Russia-Ukraine BIT. So from this perspective, Belgium can be considered as a favorable jurisdiction. Another point for consideration is the answer to the question whether it is possible for a creditor of an award rendered against a foreign state to attach the assets held by an alter ego of foreign state in a given jurisdiction, and may property belonging to persons subject to national and international sanctions be attached. As far as I have heard, it was in a previous panel, it was a discussion whether participants of Wagner Group or other paramilitary organizations, private military organizations can be held liable financially. And my wishful thinking is that they should, and they fall under the criteria of alter ego. However, each state has its own test for alter ego, for defining if the corporation is an alter ego of a sovereign. So a critical issue is to try to at least bring on the table the discussion of specific international agreements, which would unify the criteria for defining if a corporation or an individual is acting on behalf of an aggressor state. Of course, that should have sort of emergency nature, this kind of treaty, which should be invoked or enabled only in case of commitment of a crime of aggression or crimes against humanity. But this is a case when we are talking about the Russian invasion in Ukraine. So the further pillar is considering the counter strategies which a sovereign state might employ during enforcement of judgment of any type, including arbitral awards. If you are speaking of arbitral awards, of course, the sovereign will challenge the mere arbitration clause. Usually the states, and there are a lot of case law on that matter, they try to invoke bad faith or money laundering allegations, which make the enforcement challenging and adds a lot of arguments to the credibility of awards or decisions. I have already mentioned the alter ego concept, and this is the concept which is beloved by the states, and they usually invoke it when the case is the corporations, when the creditor, award creditor, or judgment creditor is trying to enforce the judgments at the cost of third parties. And probably the fourth major counter strategy which state might employ is challenging the procedural issues, and the most important one is the service of documents. Usually, Russia has always been referring to that they were not notified of the hearings. They had not enough time to prepare their objections or other documents. So this has to be taken into consideration too. And finally, the fifth pillar is the costs. All proceedings, and especially arbitration proceedings, can be prohibitively expensive and lengthy, and potentially excluding small households and companies from suing the Russian state. However, I believe that legal society and policymakers can address this challenge by establishing avenues for third-party funding to assist those challenging Russia's actions, as well as facilitating mass claims, which is also possible through avenues of international arbitration. And finally, just a couple of concluding remarks regarding termination of Ukraine-Russia BIT. Although, indeed, Ukraine has announced plans to terminate it by January 2025, my inclination is to think that this decision should not essentially hinder any efforts to seek compensation for Russia's actions in occupied territories. As participants probably know, the so-called sunset provision of the treaty, the investments already made with the protected under the treaty and are already protected until would be already protected until January 2035 in case the BIT will be terminated. So, like I said, that would not essentially hinder the enforcement. And finally, the next step is for the international communities to decide whether to facilitate arbitration efforts, thus enable the lawful seizure of Russian sovereign assets and to assist victims of aggression, or to wait for changes in international law that could potentially strip those assets of sovereign immunity altogether. However, the recent news and the recent pace of evolvement of international relations, in particular the behavior of G7 nations, shows little support for such changes, so this so-called Grosjean moment may not arrive at all. Therefore, we have to bear in mind that Russia-Ukraine BIT stipulates the so-called cooling-off period, and bearing that in mind, the major law firms and the representatives of the major Ukrainian law firms are present here today. I encourage to prepare mass claims and to start off that cooling off period, which would at least go beyond the mere fixation of the damages, which was facilitated by the Ministry of Justice of Ukraine, but create a background for some specific actions. And that would be already a proactive stance, proactive position. Thank you very much again. I'm finished. So unfortunately, due to unforeseen circumstances, I have to leave this meeting, but if you have any questions, I'd love to address them right now. Either Alexander has my contacts. I would love to discuss in person any pillars of this strategy of enforcement further with anyone who wishes. So thank you very much, colleagues.
Thank you, Armo.
Thank you, Mark. If there are no questions, I think we can move on to our next speaker, Alexander Frolov, who will speak about the seizure or the confiscation of Russian foreign assets in Ukraine and worldwide, and risks which are connected with this process. Alexander, please, the floor is yours.
Thank you very much, Andrei. Thank you very much, colleagues. First of all, I would like to say that I'm very much pleased and honored that it is the third year of war, but the question of how to get Russia accountable is still in the center of academic and practical interests. And I'm very much honored to be on this Ukrainian panel that I think will supplement to some extent what our international practitioners and academics have mentioned through their perspective. In this regards, I would kindly invite to open my presentation if possible and seek some assistance in this respect.
Sorry, I need 1 minute. Your presentation. I open this.
Thank you very much for this. So we can begin. And as one knows, waging war has never been cheap. Can you please turn to the first slide? But confronting the inevitable consequences of massive invasion by the Russian Federation, what includes social, economic, political, and other factors, can be even more expensive. It is already the 10th year when Russia wages an undeclared war on Ukraine, and Ukraine's efforts to get access to enemy states' assets become even more important. Over this 10-year period, Ukraine has been using all of the remedies available to it in order to use its war efforts. This includes changing taxes, state borrowers at international and internal markets, accepting donations of all form from all participants and parties, including cryptocurrency, all sorts of donations, and sale of state property is also on the rise. Next slide, please. All of the measures that Ukraine takes with a view to take on Russia's assets, they can be viewed through the actions that are taken within the sovereign territory of Ukraine and outside of these boundaries. The measures Ukraine takes can also be different depending on whether Russia holds them directly in its own name. And as the previous speaker has mentioned, Russia can be very sophisticated when it comes to hiding its money and ownership. That's why it's unusual when it holds its asset in the name of companies related to it, state institutions, state corporations, and other organizations maintaining very close ties with the Russian Federation. Next slide, please. When it comes to trying to seize on the property Russia holds abroad of Ukraine, Ukraine relies on international legal framework that is in place. And the previous speaker has touched upon some of those mechanisms and the pillars, what he called, that should be taken into account while trying to get on the assets of the Russian Federation. I won't spend too much time of the attention towards this because my presentation is focused on the problems enforcing on Russia's assets and the assets of Russia-related businessmen may have in practice. Next slide, please. But I will briefly summarize that overall, the actions Ukraine takes abroad of Ukraine, including political efforts, namely to turn on the frozen assets to the compensation fund for their further distribution among those who suffered for the Russia's action. Information exchange regarding sanctions that lead to further sanctions, and we all know about the ever-increasing sanctions burden on Russia and its businesses with a view to stiff and to get as much of the money out of the economy with a view to make the invasion even more problematic. The actions taken by Ukraine also including entering into bilateral security agreements. We all have heard that there has been a number of them signed, but interestingly enough, some of the agreements contain provisions for holding the enemy state responsible and how to treat the assets held in the territory of our partner that signed a bilateral security agreement with us. Also, Ukraine takes measures to foreclose on Russia's assets abroad by conventional measures, and our colleagues and speakers from the first panel touched upon this issue. Some of the examples include Naftogaz award that has been enforced against the Russian Federation in the territory of the United States, and recently in 2023 at the end of the year in the United Kingdom. Next slide, please. But well, we need to understand that Russia and Russia's proxies, they do not sit idle, waiting until Ukraine or Ukraine's partner take on Russia's property. They apply all of the measures available to them. They hire the best lawyers they can with a view to circumvent sanctions regime, to make foreclosure on the property as difficult as possible. This includes all sorts of anti-takeover measures, including fraudulent transfer of property to a friendly businessman or business, friendly dilution of shares towards the management, thereby diminishing the shares of held by the Russian Federation or Russia-related businessmen. And this should be taken into account that this is not an easy walk for Ukraine to take over the assets in the sovereign territory of Ukraine or otherwise. Next slide, please. Just to name a few and supplement the list I've already mentioned, the techniques that we have seen in practice include creation of unbearable and at times fraudulent debt towards the entities that may be subject to foreclosure, to ensure that when the asset is taken over, Ukraine faces significant difficulties with managing it, and at times had to make a significant injection of money or capital with a view to just maintain the asset. At times, so-called white knight and those who are engaged in corporate law know that at times an apparently legitimate business comes and try to save and buy stock from a Russia-related business, or just step into the Russia's place with a view to disguise the ownership, making thereby impossible to take over the property by Ukraine. But at times it may be viewed that such transactions have fraudulent nature and made at significant undervalue. Also, I already mentioned that at times significant and aggressive management incentive plans is being adopted, thereby the property that Ukraine can get onto is significantly less than it could be. Also, the enemy, and here I mean Russia, launches a coordinated campaign against Ukraine, saying that it's corrupt, that it is unprecedented how media approached this issue. At times, it is when a proper investigation is being made, it appears that it is Russia and Russia-related businesses that stand behind those media attacks, especially that start when Ukraine tries to seize the property. Also, there is known that Russia is engaged in wide-scale lobbying campaign with a view to stop or at least make it very difficult to take on the property that could be subject to foreclosure. Next step, please. But another important thing is that Russia not only applies the anti-takeover techniques and engages in political and media campaign, it also makes direct threats of diplomatic and political coercion to Ukraine's partner, which at times are effective in a way that taking over the property may be difficult. We have not seen yet how our Western partners effectively take on the property seized, with the notable exception of recent use and 50 billion loan out of the proceeds of frozen property. But that is an innovation, and until recently, and it is the 10th year of war, it took a while to get to this point. Next slide, please. We need to understand here that all of those attempts in view of the harsh resistance that Russia and Russia-related businesses apply against Ukraine and its effort to get compensated for the damage in the interest of its citizens and everyone who has been affected, it faces fierce opposition. And we already mentioned how the mechanism, and Uliana Bardin has summarized how the effective international arbitration may be when it comes to getting one accountable. So what Russia and Russian businessmen do is that they are trying to abuse the perfectly legitimate mechanism of investor-state arbitration by saying that the takeover property was illegal. So such businessmen have already initiated at least one public claim against Ukraine amounting close to $1 billion related to Sands Bank. And earlier this year, there was a request for arbitration filed in ABHH Holding versus Ukraine, which is a holding company for the Sands Bank and some of the Russian businessmen standing behind that holding company. So to sum up their claim, they seek to find Ukraine accountable for the sanctions that have been applied and that resulted in the takeover into the state property of Russia-related bank. Also, when foreclosing assets of a Russian businessman whose name is Kudinatov, interestingly enough, that businessman is deemed to hold a yacht for Mr. Putin. Shell, which is a very known public corporation, has announced that it will likely bring an investor-state proceeding against Ukraine because it believes that its rights as a third party was affected by the decision of Ukraine's court, by which the beneficial ownership of Kudinatov in a Ukrainian petrol station business was taken over. So this brings us to the question that if the attempt to get over the property in the sovereign territory of Ukraine will be ever increasing, and we hear how here and there the Ministry of Justice files those claims and seizes shopping malls, large factories that were previously owned by the Russian Federation. Will it result in a water flow of investor-state arbitration against Ukraine? And if yes, how those perfectly legitimate mechanisms as bilateral investment treaties and multilateral investment treaties that have not been specifically designed for very specific situation when a war has started and an invasion and where the confiscation is resulted with an invasion and a legitimate use of countermeasures by a country that is a victim of the invasion. So what to do in such circumstances? So I would like to pose a question mark here because there is no definite answer to that question, but we need to understand that if the attempts to get onto Russia's property abroad of Ukraine will also be successful, are the countries where the assets are located may also start seeing such a similar waterfall of claims against it under the respective treaties. And there are already first signs of that coming because, for example, Alisher Usmanov has not filed its claim against a particular country, but it has already initiated a claim against bank or a UBS bank in, I believe, Switzerland or Germany, where he held his money, saying something that the bank has reported towards the filed suspicious activity report that resulted in unfair sanctions. That's why we may see some very interesting disputes that would touch upon the very core of state powers to sanction those who engaged in efforts that damage Ukraine and its interests. Thank you very much, and I look forward to any questions that may be down the line.
Thank you very much, Alexander, for such an interesting overview. From my side, maybe just one quick question. You mentioned that the sanctioned entities often resort to various unfair tactics in order to avoid the seizure of their properties, such as fraudulent transactions and other similar measures. So, are you aware how the state entities or other parties involved actually fight with these fraudulent actions by sanctioned entities in order to actually seize the assets, either in Ukraine or maybe in other countries?
Thank you very much, Andriy. Indeed, this is a big problem because actually what is happening is that in such a circumstance, Ukraine will have to react to some of the techniques that has been applied previously before the seizure. Take one example of unbearable debt. So at times such unbearable debt is created artificially with the use of so-called fraudulent transactions or the transactions that has been aimed with the use to inflict harm. And interestingly enough, debt under such transactions matures after or immediately after the interest or share are being transferred to Ukraine. So this creates a difficult problem. What Ukraine has to do if after they taking over the asset, it has to inject a lot of funds effectively to repay the creditor that at times is affiliated with Russians. And we all know that in the recent years, the concept of fraudulent transactions or transactions that are aimed to cause harm has been developing. And I think that the practice of Ukrainian courts will soon see some significant developments in that concept too. Hopefully that will be decided favorably to Ukraine and take account of unfair behavior and behavior with a view to cause harm.
Okay, thanks a lot. Maybe some other questions from the audience or other participants?
Alexander, I have a question. What do you think about perspective to use arrested under sanction Russian assets for enforcing in private cases, for example, Ukrainian court decision, or enforce and using this asset enforcing investment arbitration awards, because last few weeks in Ukraine we read a lot of articles about this, about companies, you have right for these assets, let's fighting with Russian oligarchs because it's perspective way for enforce your arbitration awards or Ukrainian decision. So what do you think about this? It's realistic or it's mystic?
Thank you very much. It's indeed a wonderful question. I think it's not entirely straightforward because it touches upon the very heart of the concept of corporate law and separate, distinct legal entities that are different from their owners. When it comes to applying sanctions, the current legal framework and the legal framework that is being developed with a view to take into account all the techniques I've mentioned, it effectively, to some extent, disregards the corporate ownership of interim companies, going directly towards the beneficial owners. And what is being seized, at least in Ukraine, is the beneficial ownership, disregarding all of the interim companies. There may be dozens of them, but Ukrainian courts, by applying sanctions regime, which is in effect the essence of Ukraine's national policy, goes directly towards the beneficial owner. But when it comes to private enforcement, I think my colleagues from private enforcers will stop here too. We have to take into account that when it comes to enforcement, it still goes through separate legal liability, and we also understand that at times businesses have been structured in a way to get benefit of separate legal entities to ensure separations of individual and its asset. But I have seen some very recent and interesting practice seeking to develop the concept of pursuing the corporate whale. I think it was the case of State Guarantee Fund of Ukraine, some very recent practice, which stretches the boundaries of Ukrainian law, Ukrainian corporate law, and I think we may also see some very interesting court practice of higher courts of Ukraine, how to address those issues when separate corporate legal liability is used to hide Russia's beneficial ownership.
Thank you for your answer.
All right. If there are no further questions to Alexander, we will move on to our next speaker, Ivan Zhabotinsky, who is a private enforcer in Ukraine. And the topic that he will cover concerns the enforcement proceedings against Russia in Ukraine. Actually, it should be a very interesting topic because we all know that there are quite many default judgments are rendered by Ukrainian courts against Russia, but at least myself, I'm not aware of any, at least partially successful enforcement of those judgments against Russian assets in Ukraine. So, Ivan, please, the floor is yours.
Andrei, thanks a lot for representing me. Indeed, you're right that we don't have any successful enforcement, unfortunately, and about this I will speak. So, I'm private officer, and I to share my point of view about the situation, what's going on with enforcement of decision against Russia or against entities somehow related to Russia. I hope you hear me well, because my internet connection is not stable. I don't have electricity a long time, and during this time the connection is worse and worse. Hear me well?
So
Yes,
far we can hear you.
Perfect, thank you. For the purpose of enforcement, it really doesn't matter what the source of enforcement document, whether it comes from court or it is
unfortunately now a bad signal in Ukraine, and our few speakers now without electricity. So maybe I just now connect with one, but our next speaker also without signal. Yulia Bezdola, head of Association of Judgment or Judges Self-Governments, and for Andrei, for your agree, can I share presentation of Yulia, my screen? And for your attention, she's unfortunately now without any signal, but she sent me.
Hello,
Oh,
hello everyone. I'm so sorry. I tried to connect through the mobile phone, and I guess my computer doesn't work. This internet speed is not enough. So if you're hearing me, I can carry on. If the connection is bad, we can skip my presentation and move forward.
Ivan, I need just 1 minute for share your presentation to the screen.
Thank you. So, as already said, that it really doesn't matter what is the source of enforcement document. That process of enforcement, the same anyway for judgment or arbitration award. So for the purpose of this presentation, I divided all of enforcement process against Russia or entities related to Russia for 3 categories. And the first category is the judgment against Russia as it is. So since the Ukrainian court in 2022 started issuing judgments for recovering damages for in benefit of Ukrainian companies or individuals, we already started trying to enforce all of these judgments. So in the beginning of 2023, first enforcement document was filed in the Ministry of Judgment that have to enforce all of this document. Please, first slide. Yeah, thank you. So by now, I checked the information a few days ago. We have 407 enforcement proceedings against Russia. There are different debtors. They are Russian Federation, Ministry of Justice, Government, Ministry of Defense, General Prosecutor's Office, Embassy in Ukraine, etc. Unfortunately, none of this judgment was successfully enforced, and all of these case files are pending currently. Why it happened? And one point what I want to mention, that all of these enforcement files are combined in one common enforcement proceeding that is, honestly speaking, not legally right, because under Ukrainian law, we can combine enforcement document just against one debtor, because we have different debtor combined in one common enforcement proceeding is not really correct. But that approach anyway didn't help to Ministry of Justice to enforce these documents, unfortunately. Why it happened? Obviously, the main reason that the debtors don't have any assets in Ukraine. Even they don't have tax number through what private enforcement and state enforcement officers search for assets. So we can confirm or say that the enforcement process for recovering damages from Russian as it is doesn't really work, unfortunately. But the creditors still have chance for compensation, because we know that now we are feeling international recovery fund, and hopefully those who suffered from the aggression will get their money. So first category like this, 407 enforcement files, and none of them enforced. Next slide, please. The next category is enforcement proceeding against entities that under the sanction. Today we have 7,125 legal entities under sanction. It's official statistic for a few days ago, and more than 10,000 sanction for individuals. Of course, main of this sanction are freezing their assets. And obviously, if your assets are freezing, you cannot fulfill your monetary obligations, you have creditors, you have claims, and finally you have enforcement file. And because of this, actually we have two competitive procedure, one sanction procedure and one enforcement procedure that goes hand to hand, and targeting both of them for assets of debtor. The current legislation is built that the sanction legislation has a priority. So unfortunately, enforcement officers couldn't to see the money from the bank account, the foreclose for real estate, quiet or just another property, real hard, and not much enforcement officer are ready to enforce documents and competing with state who try and also get this asset. So we have to admit the enforcement of such documents, but very, very hard. Next slide, please. And we have third type of enforcement procedure. It's enforcement procedure against or sanction process. Also, we have judgment for seizing property in favor of state. So by now we have 41 judgments. It's a statistic for a few days ago against 48 entities. I don't know exactly how many enforcement procedures already started against these entities, but the news enough. We have enough news about the information of selling this property in enforcement procedure. So we can admit that this process, it's not massive. We don't have so many such kind of enforcement proceeding, but it's quite effective. The barrier, in my opinion, that this process is doesn't enough regulate it, because the after the court decision, this decision have to be submitted in Cabinet of Ministry, and the Cabinet of Ministry have to decide what's the way of enforcing of this. Most of way are through the enforcement procedure, but I guess not all of them. So the last one slide, please. Yeah, conclusion. So to summarize, we have three types of enforcement procedure against Russia or someone who related to Russia. If you want to recover damages from Russia as it is, you wouldn't successful. Unfortunately, if you are not lucky and you have creditor under the sanction, you could be successful, but it's very difficult. And if you are state and you want to take the active from under sanction entity, you would be successful. That's it. Thank you so much. If you have a question and I could answer, I would be happy.
Thank you, Ivan, for your presentation. Just one question from me. If we have a Ukrainian court judgment against Russia as a state, do you think it's possible to enforce it in Ukraine against a sanctioned private entity? Or maybe it's totally different, like the proceedings? How would you comment? Because otherwise, if there are no assets owned by Russia in Ukraine, and actually no left, probably there are no chances to enforce Ukrainian court decision against Russia in Ukraine.
Yeah, it's good question, and unfortunately, enforcement officers thinking formally, and if in the enforcement document written that the debtor is general prosecutor, so he wouldn't try to move this liability for someone else. That's too complicated, and I don't believe that it could happen. So we are thinking very formal what's written in the enforcement document. So that's it. Unfortunately.
So the fact is probably that the most use of Ukrainian court judgments against Russia as a stage is filing for the damages register as a proof of damages caused. Because in Ukraine you cannot enforce this judgment because there are simply no assets, and abroad it might be quite challenging because the courts in foreign states would not overcome sovereign immunity of Russia. That's why.
Exactly.
Okay, maybe some other questions from other participants. Well, if no further questions, then thank you, Ivan, again. And we move, I think, to Olga Verba.
Thank you.
Alexander, right?
Olga Verba also now without internet, without any signal. She just called me, but she also sent me presentation, and I try to share to my screen. Let's wait 1 minute, please.
You, ladies and gentlemen, the topic of my presentation is problematic issues of national courts' decisions enforcement in cases of compensation for damage caused as a result of Russian aggression. As a result of Russia's armed aggression, Ukraine suffers daily losses. The energy, logistics, agricultural and other sectors have suffered property damage worth tens of billions of dollars. For example, according to the Kyiv School of Economics, the agricultural sector has suffered direct losses from Russian aggression of around 80 billion as of February 2024. Among the main ways of the compensation for losses caused by the Russian Federation are international investment arbitration. This option is available on a limited basis and only if the investment object is located in temporarily occupied territory or in the Russian Federation. European Court of Human Rights. The Russian Federation has left the jurisdiction of this institution. Ukrainian court decision on damage recovery and its enforcement, or recognition and enforcement in another country. Another country court decision where Russian assets are located. International compensation mechanism, the International Register of Damage. Advantages of investment arbitration as a mechanism for compensating damages caused by the war with Russia. The most effective tool in the arsenal of big business, it allows for compensation of a wide range of damages. In investment arbitration, compared to Ukrainian and foreign courts, the risk of a claim being dismissed due to a lack of jurisdiction is lower. High amounts of avoided damages, and in investment arbitration, post-award interest is traditionally avoided. And there are some disadvantages of investment arbitration as a mechanism for compensating damages caused by the war with Russia. Firstly, investment arbitration only allows for the recovery of losses of assets or business opportunities located within the territory of Russia, including both its internationally recognized territory and the Ukrainian territories that have been annexed and are under its actual control. This mechanism is not suitable for recovering damages caused, for example, by the impact of Russian missiles on a power plant or a factory on Ukrainian territory, or by the torpedoing of a ship in Ukrainian territorial waters. Extremely high cost of the procedure, millions of dollars. Duration of dispute resolution, from 3 to 5 years. difficulties at the stage of enforcement of arbitral awards. Therefore, the problem of enforcing the judgments of courts in cases of compensation for damage caused as a result of Russian aggression, which is the final stage of the process of defending the rights and protected by law interests of natural persons and legal persons, is important, difficult, and debatable, since enforcement proceedings determines efficiency of justice. However, practice testifies that today enforcing these judgments of courts remains not successful and not enough legislatively regulated and ineffective legal institution. There is a gap in Ukrainian legislation regarding the procedure for enforcing court decisions when the debtor is another occupying state or aggressor state. The issue of special non-contractual civil and international liability of foreign states for damage caused by armed conflicts is inextricably linked to sovereign immunity. Sovereign immunity should be understood as the ability of a sovereign state not to be subject to the authorities of a foreign country. In this regard, the doctrine of international law distinguishes the following types of jurisdictional immunities: judicial immunity from lawsuits, immunity from securing a claim, including a preliminary one, immunity from the enforcement of court decisions, property immunity from interference with property. The main problem in collecting damages from Russia is the country's sovereign immunity. Part 1 of Article 79 of the Law of Ukraine on International Private Law established sovereign immunity, according to which filing a claim against a foreign state involving a foreign state in the case as a defendant or a third party may be allowed only with the consent of the respective state. The principle of sovereign immunity is based on the principle that a state is not subject to the jurisdiction of the courts of another state without its consent, and it follows from the Latin in parem non habet jurisdictionem. An equal does not have jurisdiction over an equal. However, ex injuria non oritur jus. No right arises from lawlessness. The European Court of Human Rights indicates that establishing immunity for a particular state within the framework of civil proceedings has a legitimate purpose to comply with the principles of international law aimed at achieving courteous and good relations between states, which manifests itself in respect for each other's sovereignty. In the case of Loizido versus Turkey, 1998, the European Court of Human Rights ruled that the Republic of Turkey should pay compensation to the applicant, including compensation for moral damages as a result of the illegal occupation of the northern part of Cyprus by the Turkish armed forces, where the applicant was born and lived. However, no information has been established on the actual payment of damages avoided by the foreign state defendant for material and moral harm. The established practice of the International Human Rights Court shows that the unified norms on state immunity contained in conventions are applied by the courts in accordance with the principles of customary international law. At the same time, the purpose of granting immunity to a foreign state during the judicial proceedings is precisely the criteria of courtesy, respect, and good relations, which undoubtedly cannot apply to the circumstances of war. The national legislation of the Russian Federation, unfortunately, allows the Constitutional Court to make a decision on the impossibility of enforcing a decision of an interstate body, since such enforcement contradicts the Constitution of the Russian Federation. And such a practice was already in place in the Yukos case. Judicial practice in cases on claims on individuals, citizens of Ukraine against the Russian Federation for compensation of material damage as well as moral damage began to form since 2016. Until April 2022, there was no uniform approach in Ukrainian judicial practice on this issue. On the one hand, courts satisfied the claims of individuals and legal entities relying on the norms of the Constitution 1996 as norms of direct action and on general principles of law. On the other hand, courts dismissed the claims, citing the need to obtain the consent of the competent authority of the aggressor state and or the occupying state to enter into the judicial process on the territory of Ukraine. Starting from April 2022, the Cassation Civil Court within the Supreme Court has formulated an approach according to which the Russian Federation cannot enjoy immunity from jurisdiction in this category of cases. For example, a ruling of the Cassation Civil Court of April 14, 2022. For comparison, a ruling of the Cassation Civil Court of May 13, 2020. The denial of state immunity to the Russian Federation in Ukraine in certain cases can be justified in particular by countermeasures, the our state being in a state of individual self-defense in accordance with Articles 51 of the UN Charter, takes to induce the aggressor to fulfill its international obligations. Initially, the Cassation Civil Court within the Supreme Court applied the so-called third exception, stating that since the Russian Federation has exceeded the limits of its sovereign rights, denies the sovereignty of Ukraine, violates international legal obligations, wages an aggressive war against our state since 2014 and causes harm, it cannot enjoy the corresponding immunity in the courts of Ukraine. Since May 2022, the Cassation Civil Court has somewhat expanded and improved its reasoning. For example, in the rulings of the Cassation Civil Court of May 18 and of June 2022. In addition to the third exception and the argument about the Russian Federation's actions beyond its sovereign rights and in violation of the norms and principles of international law, the Supreme Court also applied the anti-terrorism exception, noting that upholding the immunity of the Russian Federation is incompatible with Ukraine's obligations in the field of counterterrorism. Therefore, the realization of the right of victims of armed aggression to apply to court, including the enforcement of a court decision as an integral part of access to justice, should not directly depend on the actions of the aggressor state, which is already not interested in achieving the goals and objectives of justice, but also through the instrument of granting consent to the administration of justice in respect of persons who have suffered damage caused by it will have unlimited opportunities to hinder the realization of justice. And therefore, the very idea of obtaining the consent of the aggressor country to hold it civilly liable for property and or moral damage caused to individuals is unacceptable. In light of the progressive trends in the development of international law, as well as compliance with the modern standards of social development, the application of functional limited immunity seems to be the most rational model of legal regulation of this procedure. We propose to introduce exceptions to state immunity in Article 79 of the law of Ukraine on international private law. In addition, we propose to amend the law of Ukraine on enforcement proceedings, expand the powers of private enforcement officers, and empower them to enforce court decisions and decisions of other judicial bodies against the Russian Federation, and following the example of French law, empower them to certify the facts of damage fixed losses. Thank you for your attention.
Yes, thank you very much. Unfortunately, it's not a live speech by Olga, but for my opinion, she showed to us main question and sent to our academic and practical society main ideas about changes in legislation. So we will have round for discussion. We have round for next events, and our next speaker, Yulia Bezdola, head of Association of Judges Self-Government. She's also unfortunately without internet, and she's also sent to me a record of our speech about judges' experience about courts and claims against Russia. So I will share to you this video.
Greetings, dear community. I'm very grateful for the invitation to speak at your event. 2 years ago, Ukraine faced a full-scale invasion by the aggressor state, the Russian Federation. And on April 24, in 2022, the Ukrainian judicial system received a new category of cases on recovery of damages from the aggressor state when the Supreme Court, namely the civil jurisdiction of the Supreme Court, expressed a legal opinion that the aggressor state, the Russian Federation, having committed an open act of armed aggression against of Ukraine and thus violated its international obligations and norms of international law, and accordingly lost the opportunity to invoke its immunity. According to the position of the Supreme Court, Ukrainian courts can ignore the judicial immunity of the Russian Federation in cases of recovery of damages caused by armed aggression and consider cases against Russia in Ukrainian courts. This position has become widespread, and in 2 years of judicial practice of Ukrainian courts, a lot of such cases have been considered and decisions have been made. This practice applies to both civil and commercial cases. Civil, where the plaintiffs are citizens of Ukraine and the defendant is the Russian Federation, and commercial cases where the plaintiffs are Ukrainian businesses and defendant in such cases heard by commercial courts whose representative I am. The defendant is also Russia, as a rule represented by its bodies, the Ministry of Defense or the Ministry of Justice, regardless of the fact that a court decision is not required for registration in the Register of Damages, which has opened in the Netherlands. The applicants believe that the presence of such a court decision is a guarantee of receiving real compensation. Courts, when considering such cases, determine the amount of such damages in a proper way, analyze the evidence base, analyze and confirm the very fact of the event. Accordingly, citizens and Ukrainian businesses believe that this will help them later with the possibility of receiving compensation for the damage caused by the aggressor state. In fact, only the court of the first instance considers these cases because there is no subject who can file an appeal or a cassation complaint because the Russian Federation does not take part in such cases and does not accept such a procedure. Therefore, the decisions made are not appealed and all practice is developed on the basis of legal positions of the Supreme Court, but by the courts of the first instance. There are two big problems with these cases. The first big problem is the judicial immunity of the Russian Federation because the position ignoring of the Russian Federation's immunity abroad is debatable due to the fact that Ukraine suffers a lot from Russia's brutal aggression. The legal community in Ukraine mostly supports the possibility of considering such cases in Ukrainian courts based on the same concept proposed by the Supreme Court, but many of our colleagues and partners abroad do not share the positive perception of this practice because they believe that it violates the basic principles of international law and international relations, and it's not a fact that such decisions will be legalized, and it's not a fact that they will be positively perceived, including by other states, including the seized assets of Russia. It should be noted here that Ukrainian courts that consider cases of recovery of damages, both civil and commercial, are not the only ones that use this approach because we also have superactors of High Anti-Corruption Court, which seizes assets belonging to Russians on the territory of Ukraine, also uses the same construction. Therefore, for Ukraine, it's a general widespread practice which was chosen by Ukraine in the person of its bodies, in particular the judiciary. The second big problem is the procedure for notifying Russia about the consideration of such cases. Unfortunately, we have neither a legislative confirmation of the procedure for such a notification, nor any clarifications in the decisions of the Supreme Court. So the way and the opportunity to make such a notification is very important for judges of the first instance, who must ensure the general principles and adhere to the principles of judicial proceedings, in particular the right to be informed that a case is being heard against you. There is no single practice and no single approach. In my personal practice, I, like some colleagues, try to inform the aggressor states that it is a defendant in such cases through the embassies of the Russian Federation in other third countries. I tried through embassies in different countries, Romania, the Baltic states, Poland. For some countries, there is no reaction. For Romania, there was once a response from the Russian Federation to the Ministry of Foreign Affairs of Ukraine in another case when they informed that they do not waive their judicial immunity, and Russia accordingly refuses the fact that the Ukrainian court is hearing the case against it. According to this case, in my opinion, the Russian Federation knew for sure that such lawsuits had been filed against it. The general position is that at the time of a start of a full-scale war on February 24 in 2022, Ukraine announced the termination of diplomatic relations with Russia. Therefore, the relevant convention on sending documents does not apply. It is impossible to send documents. There is no postal connection with the Russian Federation, and that's why the majority of Ukrainian judges are guided by the analogy of our legislation, the analogy of the order in which we inform the participants of court proceedings who are in the territories temporarily occupied by the Russian Federation. Ukraine has adopted a law on ensuring the rights of people in temporarily occupied territories, on the basis of which we notify them by means of an announcement on the websites of the Ukrainian courts. In the same way, the Russian Federation is notified by colleagues who do not use the embassy's instrument, based on the fact that the Russian Federation has the status of the defendant and applied the analogy of the law. This way can also be criticized because, as we understand now, websites are blocked, and therefore it's unlikely that such messages on the website of Ukrainian courts are generally available in Russian. In my opinion, another channel of communication should be made. It's another embassy's no messages on website. It should be created a separate site in a third country about which Russia should be notified diplomatically, or this information would be published so that there would not be at least accusation that the basic principles of judicial proceedings in such cases were not ensured, and these court decisions could be legalized if accepted in foreign jurisdictions. No less debatable is the question in general, whether it is correct for Ukrainian courts to evaluate such cases. So the position is below. In response to the violation by the Russian Federation of the imperative norms of modern international law, state authorities, the court is the only body that conducts proceedings on the territory of Ukraine, authorized not to recognize the abuse of law and the use of the principle of sovereignty of the Russian Federation in violation of the principle of sovereign equality of states, and accordingly the court recognizes itself as authorized to consider such cases. So after the beginning of a full-scale war, the courts of Ukraine, considering the case where the Russian Federation is identified as a defendant, has the right to ignore the immunity of this country and consider cases of compensation for damage caused to an individual as a result of the armed aggression of the Russian Federation based on a claim filed against this foreign country. Such praxis is being built for the third year of a full-scale war, and since such cases are still difficult from the point of view of the evidence base, there must be confirmation of the amount of damages. At least this is a conclusion expert, testimony of witnesses, photo and video recording materials, and therefore it must be the procedure of fact-finding. Ukrainian judges who are considering these cases, we are worried about the fact that these cases and decisions can then be implemented, and that these decisions are accepted by our foreign partners. The opinion of our partners and our friends abroad is very important for us, for the Ukrainian judges. Therefore, since this is an ongoing process, I would be very grateful for your opinion on this matter, for suggestion, for possible criticism, because everything we do to protect the people, to protect our Ukrainian citizens, to protect of Ukrainian, to protect the rights of Ukrainian businesses. And we want our actions to be as correct as possible, as balanced as possible. And therefore, I'm very grateful for the opportunity to make this small report today. And I would be very grateful for your thoughts and suggestions, both at today's event or after it. Thank you for your attention. I wish everyone the earliest victory of Ukraine and in this war, and the earliest victory of justice in the whole world. And thank you.
Thank you very much. Maybe someone have some question. No any question.
No question for me. I think the presentations were quite clear, and we can discuss later if you wish.
So, as we are listening today, from our British and American colleagues about legal practice, about realistic approach claims against Russia. Now we collect ideas from Association of Private Enforcement Officers about changes for legislation. Also, we understand that Ukrainian law don't give to us any possibilities about state immunity, about private claims against Russia, because priority of sanction law under enforcement law. And of course, we will have nice example about using English and Wales law for fighting with state immunity of Russia, according to position of Supreme Court of England. So I think we share to our Ukrainian legal society for Ukrainian experts and academics and lawyers best practice and best approach in this field. So I hope we'll meet soon in Kyiv in person for the next conversation, and looking for best ways for practice and mainly realistic approach in this field.
And hopefully bring Mr. Mistelis to Donetsk, which will be Ukrainian again.
Yeah, it's a good idea, you know, if Lucas Mistelis was in Donetsk a few years ago and start of practice and working together with academic V.Mamutov. It's very good symbol about cooperation between British and Ukrainian lawyers, even now in our time. So if have no any question, let's talk. Thank you for all our brilliant speaker and our brilliant moderator and our organizers, State Institute of Economical Legal Research, National Academy of Science. Thank you, Alexander Frolov. Thank you, Hlistitsenko, Vladimir Ustimenko, Ivan Zhabotinsky, Alexander Scott, all our colleagues who support, Tatiana Gudima. Thank you for cooperation and support this event. So be in touch, be healthy. Best wishes for all.
Yeah, thank you, Alexander,
thank you
for
very much.
arranging this.
Thank you, Alexander.
Thank you very
so
much.
much. The event was great.
Thank you.
And bye.